Good morning. My name is Maurice Crespi. I'm the managing partner of Schindler's Attorneys. Welcome today on this webinar on business rescue. I'm joined today by Ian Fleming of Engaged Business Turnaround, by Barry Barachowitz of Schindler's Attorneys, by Tisha from the IQ Business Group, by Emma Marseille from the IQ Business Group, by Dominique from IQ Business Group, and Peter Gordon from Engaged. Morning, Willie. Good to meet you. Thanks for joining us. So the idea today is we're going to provide a general overview of business rescue, but it's important for the audience to bear in mind that COBRA is not about business rescue. COBRA is about avoiding business rescue. So the idea with COBRA is to invite businesses into our ecosystem with a view to us then contacting the business's creditors and dealing with the creditors to strike up arrangements to avoid the need for a business rescue. Now, ordinarily, business rescue outside of a COVID type scenario, one finds that you use the moratorium when creditors become aggressive. Very often the moratorium is abused because you have no defense to the case, and then it's not about rescue. And there's a stigma associated with business rescue, and that stigma now is in our view non-existent. And we're also finding that creditors are cooperating, thereby allowing us to avoid a resolution, placing a company into business rescue. So COBRA is not about business rescue. Business rescue will only occur if a creditor becomes unreasonable and starts making demands which you can't meet because of your cash flow constraints. So be mindful of that. I'm going to kick off by asking Peter to give us a general outline on business rescue, mindful of the fact that business rescue is a last resort. Peter?
Thank you, Maurice, and good morning to the participants. I'm not going to, as Maurice said, I'm going to give you an overview. So this is not a detailed analysis of Chapter 6 of the Companies Act, but certainly if you do require more technical information, please come into the COBRA ecosystem and you will get assistance. Business rescue, from a practical point of view, it allows the company to protect itself against any legal action. That's not any legal action about recovery of amounts that the company owes, but any legal action. Subject to the provisions of the Act, somebody can go to court to have the business rescue overturned if it's inappropriate, etc. But 90% of legal action against the company is a moratorium. What does that do? It protects you from any legal challenge and thereby allows you the breathing space. And this is an important point. Business rescue is not about a company surviving that should really go into liquidation. If a liquidation is appropriate, then that's the route that one should follow. However, it gives a breathing space and it allows the directors to sort out the affairs of the company under the guidance and supervision of a business rescue practitioner. The fact that the creditors are, if you like, frozen in time and are only able to be paid out in terms of the business rescue immediately frees up what we call post-commencement finance. That's quite critical to a rescue. If you don't have funding to A, keep the business going and to settle creditors in terms of the business rescue plan, then the rescue's doomed to failure on day one. Important point with security, all secured creditors are frozen as well. That doesn't mean that you alter the business rescue process alters the nature of their security. They remain secured, but just can't exercise their security. Importantly, if anybody's considering funding a company, either at a shareholder level or any level for that matter, that is on the edge, then please rather wait until the company's gone into rescue before funding the company, because by doing so, your funding immediately is classed as post-commencement finance and is therefore preferred. That means it's paid before anybody else other than the practitioner and his fees. So there's a hierarchy of payments that can be made, and anybody putting money into a company after rescue is preferred over those creditors that were owed money as at the date of rescue. important point. The practitioner can also use the unfettered assets, unencumbered rather, assets of the company, and provide security for funders. This was important in the Act because obviously who was going to fund a company that was in business rescue unless they had some reassurance that they were going to get repaid. Staff in the rescue contracts remain unaffected. Any reduction in staff numbers still has to go through the normal process of a Section 189 in terms of the Labour Relations Act reduction. And however, within rescue, if you are going through a reduction in staff numbers, it is an opportunity to fast track that process, because obviously it's quite clear why the process has started, whereas under normal conditions, you'd have to go through a communication process with staff on what the reasons rather for the cutbacks. Maurice, I think that's about it from an overview point of view. If I've missed anything, please let me know.
No, that's brilliant. Thanks so much, Peter. I mentioned earlier that COBRA is not about business rescue. There are other statutory procedures that one can utilize in these circumstances. And one particular one relates to compromises and Section 155 of the Companies Act. I was hoping, Ian, can you take us through that, please?
Yes, certainly, Maurice. Thank you very much. And welcome to everybody. Okay, so as business turnaround practitioners, and that's what we are. We're turnaround practitioners that do a lot of work within the legal framework of business rescue. At all times, from when we start engaging with a company, we're always trying to work out, and it's very important to get this right, what sort of legal framework we need to operate under, or we need to handle that company under. And the various options exist. Sometimes it's minor interventions that are required. So the company will carry on business as usual, and we'll just help them through minor distress that they're encountering. Sometimes it's an informal turnaround. We call it an informal turnaround because it's outside of the legal framework of business rescue. Sometimes it is business rescue, and in the worst case scenario, it's liquidation. Now, we try to avoid liquidation at all costs. There's no reason for us to put a company into liquidation. There's no incentive for us to put a company into liquidation, and we don't work as liquidators ourselves. Another option that exists outside the framework of business rescue is the Section 155 compromise. Now, what that entails, and one of the advantages of the Section 155 compromises, is that it's often a lot quicker than business rescue, and sometimes it's cheaper than business rescue as well. What it doesn't allow you is the legal protection of business rescue while you're busy putting the plan together. So Section 155 compromise normally works quite nicely where you've got creditors that are reasonable and negotiable and not bashing the door down, not trying to liquidate the company, but prepared to make a plan. So how it typically works is the turnaround practitioner will formulate a plan that sees creditors of different classes being compromised on the amount that is owed to them. So, for example, we'll put together a plan whereby the secured creditors' balances are compromised, and secured creditors take a haircut to the effect of, say, 10%. The preferent creditors, employees and SARS, take a haircut of 30%, and these are just examples. And the unsecured creditors take a haircut of 70%. The practitioner then gets all the classes of creditors together, and he presents the plan to them, and they vote on the plan. And what is required for the plan to pass is that 75% of the creditors by value in each class who exercise their vote are required to vote in favor of the plan. Once the practitioner has got that vote, then he takes the plan to court, has it made an order of court, and then the plan can be rolled out after that. As soon as it's made an order of court, then the creditors' balances are compromised to the extent of the plan, and the company should be able to carry on trading from a solvent position. It is quite common for a turnaround practitioner firm or the practitioner to then stay involved with the company to make sure that it doesn't slip back into distress or insolvency. I hope that answers your question, Maurice. That's just a quick overview of the Section 155 compromise.
Yeah, thanks for that. Okay, so moving on to, you'll have heard Peter, who spoke of the moratorium. He also touched on contracts. Now, what's a very, very important take home for today is the fact that contracts do not automatically get suspended, and your obligations in terms of contracts do not get suspended upon a business rescue. It's only in the event of a business rescue practitioner drafting and sending a notice to the counterparties to the various agreements, suspending the agreements. So what we've seen in the past with business rescue practitioners outside of COBRA is that they are not aware of the provision and they do not suspend the contract. And if you don't suspend the contract, and the business rescue practitioner doesn't do that, then an eviction remains appropriate, a cancellation of the lease, and then an eviction. So contracts in a business rescue have to specifically be suspended by way of the service of a notice. Contracts that are not suspended are your employment contracts. You cannot suspend employment contracts. And on the question of employment law, it's important to be mindful of the fact that nothing changes. Employees are afforded the exact same rights as they enjoyed prior to the business rescue, which means that you cannot willy-nilly go to your employees and say, we're reducing your salary by 25%, take it or leave it. That doesn't work. You cannot do that. In terms of our law, you have to comply with the notion of procedural fairness and the notion of substantive fairness. So substantively, there is a reason for a unilateral variation in employment contract, such as a reduction in salary. But from a procedural point of view, you have to consult with your employees and try and reach consensus. Now, Section 189 of the Labour Relations Act, which applies outside of business rescue and in business rescue, deals with retrenchments. And often that one has to use Section 189, which deals with retrenchments if you want to vary any employment terms. So if you want a reduction in salary, you have to consult in terms of Section 189 to give the employee the option of taking a severance pay in the event of the employee not accepting the variation in employment contract. So you still have to follow that route. So your employee's rights remain the same. There's little that you can do. In fact, there's nothing that you can do that would be unfair or that would be unfair prior to a business rescue. Employers, we've had quite a few shareholders and directors of companies say that they are prepared and they have funded salaries by injecting money into the business by way of a shareholder loan account, as an example. Now, I think that's our next topic, which I think is another very, very important take home. And I'm going to deal with really two scenarios. The first is the funding. Is it sensible? Well, let me ask Peter. Peter, when it comes to funding staff salaries, we've heard it before. The notion of post-commencement finance. Let's just deal with it, because this is a good example of where it's advisable to put a company into business rescue, even in the absence of a creditor knocking on your door and being unreasonable. So there's certain circumstances where you still should consider business rescue, and one of them relates to post-commencement finance and the security it affords to you. So I'm going to hand over to Peter just to deal with that in greater detail. Peter?
Maurice, yes, look, the important thing here, and I didn't cover it in my overview, is that when should a company be considering business rescue? And as Maurice says, even if there's no pressure from creditors, post-commencement finance is certainly one of the drivers. But before I go into that, let me just state that the company, if it's financially distressed, defined in the Companies Act in terms of business rescue, has not been able to pay its creditors as and when they fall due in the next 6 months, or the directors of the company believe that the assets of the company, fairly valued, might be less than the creditors or the liabilities of the company, fairly valued, within that 6-month period. So if either of those factors are present, Maurice often makes the comment on these webinars that there's probably very few companies in the country at the moment that aren't falling into this category. Then the directors have to consider it. If they consider it and decide that this is true, this is the case, then they are obligated to put to the vote whether the directors 50% plus one agree to go into rescue. If they don't, they still have to do a statement to all creditors and suppliers stating that they are financially distressed but not going into rescue. And I think Maurice will cover that, how COBRA can assist in that environment. However, if they decide to go into business rescue, simple resolution and an affidavit filed at SIP-C, the company's in rescue. So it really is a very straightforward process to go into rescue. However, as Maurice rightly says, do not, if you're a owner-managed business or a shareholder and you've provided shareholder loans to a company in the past and you have an approach to please fund the company that is distressed, if you put your money in, as I said earlier, before you go into rescue, it falls into the frozen pot, if I can call it that, even if it's secured, i.e. you're not going to get paid unless, or rather the only way you're going to get paid is in terms of the business rescue plan once it's implemented. So, and that could be over a long period of time, firstly, and then most importantly, it could incorporate a compromise, i.e. you're not going to get full payment, a repayment of your loan. So it really is not a great idea to put money into a company that's in a distressed situation. Rather put it in after rescue. You can agree with the directors that you'll provide post-commencement funding if they go into rescue, and your money then goes into a company. It's immediately preferred, as I said earlier, and importantly can also be secured. If it's secured and preferred, it's what we call super preferent, because subject to anybody being settled out of that security, if they had a first charge on it, for example, a mortgage over a piece of property, you can take a second charge if the bank currently holds the first charge, but obviously the bank would have to be paid out first in that first charge, even though they are caught up in the rescue. So it is critically important to put your money in post-rescue. The other important thing just on loans generally is and it's a question we always ask of business owners, stroke directors, if you've provided personal guarantees, suretyships, in favor of a funder, a creditor, then please be cautious of those, because that will still stand, notwithstanding. Remember that it's the company that's been protected, not the individual. So a bank would still have rights to go after the security holder in conjunction with the company. So they acknowledge that the company's in rescue, but they still go after the suretyship. And the important thing there, from certainly the rescues that Ian and I are involved in, we make sure that we try and accommodate that. Certainly if it's a director of the company, the last thing you want is the director in the company being sidetracked because he's terrified he's going to lose his personal residence. So we do try and work with the banks on personal suretyships, but I underline it's not a requirement of the Act for us to deal with suretyships. Maurice.
Thanks for that. We got a question. What happens when the contract, e.g. a lease, has a business rescue clause which negates normal business rescue remedies and allows them to cancel the lease? Is this legal? That's from Jenny. Thanks for that, Jenny. Very, very good question. So what I'll do is I'll start off by saying that as a litigation attorney, I'd far, far rather be on the side of the lessee than the lessor on this one. So if I were to pick sides in litigation, it would be for the lessee, because I don't believe that clause would be upheld. And I'll tell you why. Firstly, there's legislation and you cannot contract out of that legislation. So for instance, you cannot say, I agree there is certain legislation you can and certain legislation you can't. So you can't agree, for instance, there's a recent case that just springs to mind, that you will never pay your spouse maintenance. There's certain things you just cannot agree to. It's either contrary to statute or public policy. But in this case, let's just think about the logic. There's a clause in an agreement that says this is how business rescue must operate. Now, upon a suspension, that clause and the rights that flow from that clause are similarly suspended. So that clause disappears, and then you revert back to statute. So just on pure logic, I'd say that there's absolutely no ways that clause can be relied on, because that clause in itself gets suspended. I hope that answers the question. If there's anything, please, I'm happy to clarify. I'm going to ask Ian just to deal with the practicalities of business rescue and how employees are dealt with practically. So we've heard about post-commencement finance, and I've dealt with the law in relation to it. But now I think what is probably of most concern to most business owners are their employees. So how does one deal with the employees? You know, you come in, Ian, how does it work practically?
Maurice, so when the business rescue practitioner gets appointed, within 10 days he has to hold a meeting with the creditors and with the employees or the employees' representatives, or a trade union, if the trade union represents the employees. And at that meeting, he has to express to the employees or the representative whether or not he believes there is a reasonable prospect of saving the company. In other words, of returning it to a solvent going concern, or giving creditors a better return than in liquidation. Now, obviously, the employees will want to know whether the company is going to return to a solvent going concern, because that will allow them to keep their jobs. The creditors are sometimes, often the creditors will be interested to know what the company will get in a liquidation scenario versus what it will get in a business rescue scenario if the assets were just to be sold or the company was to be wound down under business rescue. So at that meeting, the practitioner tells the employees whether or not he believes that the company is going to return to a solvent going concern. If he believes it's not, then he's obligated to liquidate the company. If he believes it is, then he will normally explain to the creditors what will happen in the case of into retrenchments and so on. And he'll start to, by that time, he normally would have formulated in his head a picture of what the retrenchments story is going to look like, what the situation is going to look like. Retrenchments can commence in advance of the business rescue plan being published. This is common practice, although if anybody's been following the SAA story, you'll notice that they've just, the practitioner has just been ruled against in court because they've commenced the retrenchment process before the business rescue plan was in fact published. So that could be an interesting legal precedent and something we're definitely looking into and busy reading up on. But yes, so the business rescue plan will typically involve retrenchments in a large number of cases. And as Maurice explained earlier, the consultation process can actually be sped up quite substantially now under business rescue. And during the consultation process, what we've been doing is we've been offering employees the option of having their salaries reduced to a large extent until the crisis is over, until the crisis blows over, whenever that may be. And employees have been very open to that, as opposed to taking a substantial reduction in their salaries, as opposed to being retrenched entirely. At least then they are assured that by the time the crisis is over and the economy starts recovering, then they'll at least have jobs, albeit at a vastly reduced salary. What we've also been doing and what we've been preaching right from the outset is converting companies to variable cost structures. So what I mean by that is linking your costs to your turnover. In other words, making all your fixed costs, but with previously fixed costs, such as rent and salaries, or considered to be fixed costs, making them as variable as possible. Now, as far as salaries goes, that could be a case of reducing the salary substantially as part of this Section 189 process. And then as the company starts producing sales again and starts generating revenue again, then slowly ramping up the employees' remuneration over time. Another way of doing it is to say to the employees, and to actually tell them, we are going to pay you, your salary is going to be X% of turnover. Whatever if we do 100 rands worth of sales, your salary is going to be 20 rand, and then up to a certain limit, of course, where the salaries will normalize, presumably where they were before. So, and employees have been very open to that. So there are various options that exist for business owners and directors when it comes to salaries and making them variable in relation to turnover. And we've been doing the same with rentals as well. You would have noticed the Spur Group came out with announcement a few weeks ago saying that once they started trading again, most of their stores, they would literally only be able to afford a small turnover-based rental. And quite frankly, the landlords at this stage don't really have a choice but to accept that, because there aren't tenants banging the door down to take their place, as you can imagine. Thanks, Maurice.
Yeah, thanks for that, Ian. We've got 3 questions, so this is how we're going to deal with them. I'm going to first deal with Guida's question in relation to labour law, and then we're going to move on to the Section 155 question I'll be asking you, Ian, and then the second question by Erwin, who incidentally has become a regular, so welcome back, Erwin. I'll ask Peter to deal with. So I'll start with the first question. Reader writes, hello, what happens if the employer sends an email to an employee stating that their salary has been reduced by 50%, putting the employee in a financial situation due to this being sent in a short space of time? Well, what happens is the employee will have every right to complain about the conduct. The conduct is unlawful, and an employer cannot do that. An employer has to consult with their employees in terms of Section 189. So what Section 189 requires of the employer is to start the process with a notice, a letter, dealing with certain requirements that are spelt out in the Act. You have to set out the reasons for the proposed salary cut. And remember what I said, is you've got to propose a salary cut in lieu of a retrenchment, but the employee can always take the retrenchment as an offer, as a package. So immediately you don't have that on the table because the employee didn't have a choice as to 50% reduction or a severance package. But secondly, there's no fair procedure. So you cannot just do it without consulting. There was substantive fairness because there's COVID. We know that substantively there is a reason for it. It's not just made up. But procedurally, you need to spend time with the employees, you need to engage them, and you need to get their agreement. It's the only way is if you get agreement. Otherwise, you have to go the retrenchment route, and then you can terminate if the offer is not accepted. I hope that answers that. So moving to you, Ian, can a business rescue practitioner and or director of a company propose a Section 155 compromise offer whilst under business rescue, or must it be done by the board pre-business rescue?
So that's a good question, and the Companies Act specifically states that a Section 155 compromise can take place under normal trading conditions, in other words, pre-business rescue. It can even take place under liquidation scenario. In other words, a liquidator can effect a Section 155 compromise, but it cannot take place under business rescue. And presumably the reason for this is because under business rescue, a compromise takes place anyway. So business rescue essentially allows the practitioner to compromise the creditor's balances or the amounts owing to them, or to let them take a haircut in the business rescue plan, which is then voted on. So Section 155 compromise cannot take place under business rescue. The next part of the question says that if 75% of the creditors by value exercise their vote, what if an arbitrary concurrent creditor is miserable? In other words, he does not accept the compromise and wants to then sue for his debt, either post-business rescue or post-Section 155 compromise. Can that creditor successfully sue? The answer to that question is the business rescue process and the Section 155 compromise process is specifically designed in a way that it is, in order to make it possible for these plans to be approved, it is designed in a way that it does not require the support of 100% of creditors. You'll remember the business rescue plan requires the support of 50% of independent creditors by value and 75% of all creditors. The Section 155 compromise requires 75% of all creditors per class to approve it. So unfortunately for some creditors, for the smaller balances, they are forced to accept what has been voted on by the majority of the creditors. And that is part, as I said, that is part of the way that the whole Act, or Chapter 6 of the Act, was written, to enable these plans to be passed. Can you imagine if you had to get the vote of 100% of creditors? It would almost be impossible to get these plans passed. So it requires a fair plan to be put together to be approved by the majority of creditors. Can the creditor successfully sue? The creditor can sue. Obviously, he can go to court for whatever reason he feels. Can he successfully sue? Not easily, provided the business rescue practitioner or the turnaround practitioner, in the case of the Section 155 compromise, did everything properly, did everything procedurally correctly, did not favor one creditor or one creditor over another within a specific class. It would be very difficult for that creditor to successfully sue. Peter, I don't know if you want to add anything to that, but
yeah, and just to clarify, and it was a slip there. 75% of the creditors voting, either by person or proxy, have a say in the plan. Somebody fails to turn up at the meeting or fails to send in a proxy. Section 1524 of the Act is very clear on this. Whether you voted for or against, if the plan is adopted, it carries. Whether you fail to turn up, whether you fail to lodge your vote, whether you were present at the meeting, whether you've proven your claim or not, you're bound by the terms and conditions of the plan. So you are carried, as Ian said, but importantly by those that are voting. The most challenges we've had, and it certainly was in the early days, because when Chapter 6 came out promulgated in 2011, most of the challenges to business rescue were brought by people who believed that the company wasn't able to be rescued. So remember I said at the beginning, the directors have to confirm that they believe in a sworn affidavit that this company has a chance if it's only given some breathing space. Mainly the banks in the early days went to court and had quite a few overturned, because there was a run of business rescues in the early days of people saying, this is great, I'm not going to survive, but this at least gives me a chance to survive a little bit longer. And the banks and generally this was in the property environment, where banks would hold security over the property, but not only in the property environment, and believed that, there was no ways that this company was going to be able to develop a half-completed property development, and really the best thing would be to put it into liquidation. And by and large, a lot of those were successful. But Ian also made a very important point there. There is a clause in the Act that says if any timing is missed, so it's a time-driven process, the day on which the company goes into rescue, they've got a number of days in which to appoint a practitioner. The practitioner then, he or she has got a number of days to advise staff and creditors, got a number of days to publish a plan, etc. So all very much time-driven. And if in the appointment process, the director's resolution, the appointment of the practitioner, and then the calling of the first meeting, if any of those are missed, a affected person, deemed a creditor, a shareholder, a employee, a labor union, if the employees are represented by a union, can go to court to have the business rescue plan set aside because the time limits were not complied with. Practically, if a time limit was missed, and sometimes these things do happen, what the practitioner can do is put a clause in his plan to say, notwithstanding that the notice to creditors was 1 day late, the creditors accept by adopting this plan that they condone the breach of the time limits. So it is an important practical point to just remember that it is very much a time-driven process. Thanks, Maurice.
Oh, thanks, Peter. There's a great question here that I've been pondering, again by Erwin. Thanks, Erwin. Keep them coming. Which I'm going to debate with you guys. So it says, if the words in the lease, such as the lessee, if there's a provision in the lease that reads, the lessee is deemed to have been, the lease has been deemed to have been breached on the day preceding application of business rescue in the event that it places the lessee in business rescue. So I think it would be better framed for the purpose of this discussion. What if it said the lease shall be cancelled upon a business rescue? So in other words, the case by Gary Barachovitz, who's a panelist today, but his father is a retired judge, and there's a judgment by Gary's dad that basically says that if you don't have a right to be in occupation, well, there's nothing to suspend and eviction is appropriate. So a hell of a good question. Do you have any views, Peter?
Sure, Maurice. That's a one from left field. It is a really good question. Look, I mean, these are an interesting thing, and we often take this approach in business rescue because remember, trying to rescue a business is the cut and thrust of business as usual. So now remember, somebody's in situ. Somebody's got to go to court for an eviction order. And as Ian and I often say, the day on which we go into business rescue is the day in which we start the negotiation. It is the right to start negotiations with a plethora of people. In this case, I suspect that the landlord would have the right to evict. However, remember, in rescue, the landlord is now, we talked about post-commencement finance. Every day that the company continues to occupy the premises, the landlord is therefore providing post-rescue funding and is therefore preferred. So this might be, I'm not a lawyer, I'm an accountant, but I would argue that I would get in front of the landlord fairly rapidly to negotiate with him on the basis that his rentals will be paid. The other interesting thing with this, and I'm dealing with one advising a company that's a major supplier to Edcon, which we all know is in rescue, is how do you get your pre-rescue liability included into the rescue? It's an intriguing thing that one can do in the Act. If the practitioner believes that this, and let me just preface this by saying I'm making the statement that this is not an acrimonious landlord and has just got really, you know what, with the tenant and wants to get rid of them. That's a different story because no amount of negotiation is going to help. But if the landlord and the premises, which often they are, like a restaurant, for example, or a manufacturing business that's got all its plant and it would cost a huge amount to move the plant from the factory. If the landlord is critical to the business rescue, I would negotiate with the landlord to bring his pre-rescue liability into the rescue. And what that means is that you strike an arrangement with the landlord whereby he will be paid out, and it's unlikely to be immediately, but he will be paid out over a period of time on condition that, and then that's the important point, on condition obviously allows the tenant to remain, but also, you know, that he provide some terms and conditions for the lease or whatever. I mean, it would then be an open negotiation with the landlord. But Maurice, that's the way I'd try and deal with it. But I suspect with a clause like that, he's not contravening the law. He's not contracting out of the law, the landlord, that is, via the lease. I've seen this in a funding arrangement, people providing funding with the statement that as soon as the company makes that directors take the resolution, the company shall be deemed to be in breach, and therefore, in a normal lending loan arrangement contract, the breach conditions would come into force.
And a very common one is the forced sale provisions. So if you in a shareholders agreement where a liquidation triggers a forced sale, the prior or deemed offer the day prior to the liquidation, you also see those clauses. Well, what I would say, this is a good example of where it's really a flip of the coin when it comes to the judge, because the two arguments, Erwin mentions public policy, absolutely that would be an argument, and the counter argument would be the sanctity of contracts. So the public policy argument would be, what is the purpose? You'd be defeating the ends of justice. If every single lease agreement has this in, well then business rescue will not be possible apropos. Landlords look at this, the whole country's done it, of course they're going to do it because the landlords want to protect themselves, and that's against public policy because the purpose of the act is being circumvented by this crafty provision. So that's how I'd argue that. However, the counter argument is, well, we have to know that when we enter into agreements, that those agreements will be upheld, and the lessee willingly entered into the agreement. It's a contract. And it's important for our courts to uphold the sanctity of contracts. Otherwise, there won't be certainty in commercial dealings. So those are the two arguments. And you see what I mean? It'll be, it's one judge will go the one way and the other judge the other. And this is why litigation is so perilous, and that's why it should be avoided at all costs.
Maurice, just to add there, of course,
Yeah.
I mean, the whole raison d'etre of business rescue is very much that. It is the rescue of companies. We're trying to avoid liquidation, and importantly, the consequences for employees were a company to go into liquidation. And I would certainly argue strongly before the courts that surely a provision like this flies in the face of business rescue, because it's doing exactly the opposite of what Chapter 6 is all about.
And think of the words public policy. Okay, they speak for themselves. Okay, would the public be quite happy that legislation is passed that can be circumvented with a one-line provision that every landlord puts in his or her lease agreement? So Erwin, if you're a landlord, and if I were your attorney, I'd be loath to try and enforce the provision. Though, I wouldn't be loath. I'd try my damnedest, but as I said, I'd prefer to be on the other side. That's probably the best way to look at it. So we're going to move on, and Peter, dealing with now the directors, their involvement, but the particular anxiety that directors have had in relation to business rescue practitioners coming in, sniffing around, and possibly finding some dodgy dealings. May involve SARS, it may involve something. So what I'll ask you to do is to deal with the reporting obligations of a business rescue practitioner pre and then post his or her appointment. Peter?
Maurice, thanks. Obviously, a practitioner is, in terms of the Act, in supervisory control of the board. Practitioner has the authority to instruct directors or to request them to assist or to not assist. He can use them if he wishes, but he's not obligated to do so. Importantly, he can't remove a director unless he goes to court, unlike the Section 189 process. That's a director as his position as director. Remember, directors at the executive level are always wearing two hats. Executive, i.e. an employee of the company, and on the board as a director in terms of the Companies Act fiduciary duties. So if the practitioner discovers something that was untoward, now this has two different legs to it. A untoward in so much as it's not a criminal act. So a classic, directors have suppressed income and declared less income than they should have to the taxman. What are the obligations of the practitioner in that space? I'm not dealing with a criminal charge here. I'm talking about what would be a civil action. If that is the case, the practitioner's obligated to report any wrongdoing to the authorities. Authorities is not defined, but in my example, obviously it would be SARS. I've dealt with one that was an FSP regulated by the FSCA, or what was the FSB, and I reported wrongdoing to the FSB. Ian, and my approach to this is, once again, totally practical. Get in front, work out the figures, what they should have been, first of all, obviously. Approach the revenues, to approach SARS and make a full declaration. Now remember, with SARS, if there's a compromise in the plan, you very often find that what they get paid in the end is what would have been paid under the normal conditions anyway. SARS generally work with us on this. Ian often makes the point that SARS are not there to put companies into liquidation. On quite the contrary, they're there to recover money in order to keep the country going, and their first prize is that there's as much employment as possible, and that the businesses continue, obviously, paying into the state coffers. If it's a criminal act, and I'm talking about in business rescue here, if it's a criminal act, then the practitioner is obligated to once again report it to the authorities. Here it would be the prosecuting authorities, NPA, or the police, via the police. Report it. He has to instruct management to rectify it and to desist from doing so into the future. It's an interesting section of the Act because it doesn't have huge amount of teeth, but I would argue that if directors were perpetrating a criminal act, fraud, the practitioner would have a very strong case to go to court to have the directors removed, and then the company would take, as indeed the practitioner is allowed to do, another important point, the practitioner can sue anybody whilst in rescue. He can support a criminal case against any individual. So he's not precluded from taking the company into a legal process of opposing somebody. Pre-rescue, the practitioner is obviously not there, so it's not covered by Chapter 6. There is an obligation to generally report, and I won't go into the various acts on reporting illegal acts, but pre-rescue, the practitioners are appointed. So if a director is having a discussion with the person who's advising on rescue, and we often have this, is what the person, the advisor, would do is really nothing. I mean, other than advising people on how to resolve a situation that they've created. Maurice, I don't know if you want to cover the Disclosure of Information Act and what the obligations there on all members of the public.
Yes, yeah. I mean, in terms of the Prevention of Organised Crime Act, you have an obligation in terms of Section 34. We all do, if we're in a position of authority, to report an act of malfeasance, fraud, corruption, if the amount exceeds 100,000 rand. So every citizen has that reporting obligation, and it's a crime in itself to not report. So if you're aware, if you're a director and you're aware of fraud taking place in excess of 100,000, you will be perpetrating a crime if you do not report it. I just want to mention that the directors in a business rescue, they still are bound by all the fiduciary duties that they had prior to the business rescue, but now they have additional statutory duties, because now what they do in effect is they have to serve the business rescue practitioner. So they now are in a very, very, very different position, in the sense that they're not the captain of the ship, and they basically become statutory employees of the business rescue practitioner. Now, having said that, it doesn't mean that there's this like alpha personality who walks in and starts calling the shots. In fact, engaged are very, very different there. So I'm going to ask Ian, just against that backdrop, if you can take us through what to expect in the business rescue plan and how it works, and again, what happens on the ground.
Yes, absolutely, Maurice. As you said, so the directors have to report to the business rescue practitioner now. So very importantly, how we operate is that we know that we'll never know as much about the company's business as the board of directors does, or the owner, or the managing owner, as the case may be. We will never have the relationships with your customers and with your suppliers and with the public at large that you've built up over the many years that you've probably been in control of the company. So we are not there to kick the directors out of their seats or the CEO out of his seat and run the show. We are there to work with the directors, with the board. Most of the time, the functions of the board will carry on as normal, and we will guide them through the process, put together a business rescue plan, and implement that plan. It only becomes difficult to carry out a business rescue successfully working with the board if the board are really if they really make things difficult for us, especially if there's been some sort of fraud involved, and they're trying to hide things from us and they can't be transparent with us. Then it becomes, Peter and I have both had cases like that, and then it becomes a case of us having to take control of the board, or exercise our control over the board, and normally manage the wind down of the company. As you can imagine, it's almost impossible to return a company to a solvent going concern, where you cannot work with the board and they cannot be open with you and they cannot be honest with you. Then it's really pointless. There's no way you can. Then you might as well be in liquidation. The Insolvency Act does give liquidators certain powers that business rescue practitioners don't have, such as reversing dispositions without value or impeachable dispositions. such as in the extent to which fraud can be investigated and that sort of thing. So if we cannot work with the board, then it's normally the best solution just to put it into liquidation or to wind it down. But yes, we are there to work with the directors of the company. We've done so very successfully in many occasions, and under the COBRA umbrella, that's really our idea. It's to work with the directors and to hold their hands, implement turnaround strategies, get them out the other side as quickly as possible. Maurice?
Whilst you're on the plan and the voting, I'm going to ask Peter just to deal with this particular example, because what the example, what it tells us is that we have a shareholder who's owed R1 million, and then we have a whole host of other. We have trade creditors owed 15,000. We have directors owed 500,000. We have employees owed 100,000 who owed 100,000. So now the trade creditors are owed virtually nothing in comparison to the others. Peter, you just take us through what would happen here on the plan, because now we have the shareholders who want to call the shots and they want the plan to go their way. And what they're telling you is that because they are owed so much comparative to the trade creditors, that they should have the say. Peter?
Mauricio, look, this is a very practical problem that we often face, and it requires a bit of juggling of the votes in order to get a plan adopted. Remember what we said earlier, of the creditors who vote, or the affected parties who vote in person or by proxy, you need 75% of those voting to have said yes. So if you've got 100 rands worth of votes in the meeting, 75 rand of that has got to say yes to the plan. However, of the total votes, so of the total 100, 50% have to be independent. So 50 rand of my 75 rand example would have to be independent. What is independent? It's exactly that. Anybody who's connected with the company in any first or second relationship, so the wife of a shareholder providing money into the company, or the husband of a director providing money into the company, is not considered independent. So in an example like this, that 15,000 rand worth of trade creditors, let's assume they all turn up for the vote. So they are claimants, but they've also turned up for the vote. What one would have to do in this scenario is one of two things. Either, if you know that the creditors are friendly, i.e. you've done your homework beforehand and you found out that the creditors are likely to support. If you want to guarantee that, what the practitioner does is then hands them a proxy and says, well, please appoint me or the directors of the company as your proxy holder rather, and you know that you've got it in the bag. If they say, no, we will turn up to the meeting, slightly risky because at the meeting they might change their tune. So if you've got any uncertainty of whether this creditor is going to vote for the plan because you need them, because you want the independent vote, then the most practical thing to do is approach a shareholder and ask him to provide 15,000 rands worth of post-commencement finance in order to buy out the creditor. Sorry, let me qualify that. That wouldn't be PCF, because all the shareholders doing is standing in the place of the creditor, so buying over the creditor's claims, which often happens. People are often trading their claims, often at a discount, for others who wish to acquire the vote. As regards the directors, they too are not independent. They are dependent on the company, so their vote would also be liquidated, unlike the employees, because remember, the employees, each day the employees are working for you, whether it's for the time and labor given to the company on that day, or the first week of the month, second week of the month, they are creditors until they paid. Equally, employees are always owed leave pay and bonuses, etc., etc. So employees are always affected people in a rescue. The employees, however, are not considered as dependent. And I'm talking about clean employees here, i.e. they're not also directors of the company, because as I said earlier, directors are employees if they're in an executive capacity. So it would be a practical solution of how to deal with the trade creditor. If the directors, on the other hand, were different from the shareholders and voting and determined to vote against the plan. And you might find this, directors might think that they can do it all and they don't need assistance, where the shareholders are quite keen that practitioners appointed. And let's assume there were no other creditors, then it's just a numbers game. The shareholders would carry this plan because they have more than 75% of the possible votes. I think that's
thanks for that, Peter. Whilst we're on the plan, Ian, what happens if the plan fails? But when I say the plan fails, either it's not, the vote doesn't pass. That's one scenario. The second scenario is the vote does pass, but the plan is just dismal and it fails just because it was a bad plan.
Sure. Okay, let me first address the first part of your question. What happens if the plan is not voted in? I always say the whole business rescue process of putting together a business rescue plan and having it voted on is really one big negotiation process. So if the plan is presented and the Section 151 voting meeting happens, and during that meeting the creditors vote against the plan, then what the business rescue practitioner has to do is to say to the creditors, how would you like the plan amended for you to find it acceptable, for you to vote on it. If the creditors then want to propose amendments, then they'll put them forward and the business rescue practitioner can consider them. He's got 5 days in which to consider those amendments and present a revised plan, and then and then seek the positive vote of the creditors. Peter and I always say that we never go into a voting meeting without previously knowing what the result of the vote is going to be. We are allowed to engage with creditors during the course of presenting a plan and so on, and constructive negotiation and facilitation, and so by the time we actually go into the vote, we already know exactly, most of the time, what the vote is going to be. Should the creditors continue to vote against the plan for whatever reason, or should they not put forward reasonable suggestions as to how the plan can be amended in order for them to find it appropriate, or in order to vote in favor of it, then and they vote against it again, then the business rescue practitioner has the option of going to court to have the vote set aside as inappropriate, and to have the vote of the creditors overturned. So the business rescue practitioner, should he truly believe that the vote of the creditors is inappropriate for whatever reason, then he can go to court. He does have the remedy of going to court to have it set aside as inappropriate. The second part of your question, Maurice, what if the business rescue plan fails after having been rolled out to an extent? So say 6 months after the business rescue plan was approved, the business rescue plan is not working. Now, you say, what if the business rescue plan was dismal? That does happen. There are a lot of dismal business rescue plans that are put out there, sadly. But in most cases, it's not because of the fact that the business rescue plan was dismal. It's as a result of the fact that circumstances change. Things happen, like COVID-19 as an example, and I mean as a huge example. But during the course of normal economic environment or trading conditions, things also happen that could never have been foreseen, and the business rescue plan is very seldom carried out in exactly the way that it was put on paper. So it's normally under pressure from creditors that a practitioner will be required to admit that the plan is not working, and then consider either amending the plan and having creditors vote on it again, or liquidating the company. Most of the time, the business rescue practitioner will amend the plan. He will publish it again as per the normal Section 151 and 152 process. He'll call a meeting of creditors, and it will be once again be required that a simple majority of independent creditors vote in favor of the plan. What the business rescue practitioner can do when he's formulating the initial plan is to put a clause into the business rescue plan that says any amendment to the plan that is required during the course of its implementation will require a 51% vote of creditors or independent creditors in order for it to be passed. So that is typically what would happen once if a plan is not being implemented or not being rolled out or not succeeding in its implementation.
Thanks, Dan. I see we're out of time, so I'm just going to conclude just by explaining how COBRA works. COBRA is a pro bono initiative. The idea is that you enter the ecosystem, and all professional fees that we have, over 1,000 consultants now, all professional fees will be waived if they come between a successful business rescue and a liquidation. So in other words, there will be zero charges to rescue your business in those circumstances. Importantly, if you find yourself in an invidious position where you have to liquidate your business because the plan didn't work, so long as you came into COBRA right in the beginning and you gave COBRA its best shot, the costs of the High Court application will be covered by COBRA, and that's between 30 to 50,000 rand. So it's a no-brainer. Why wouldn't you think about it? Why wouldn't you join COBRA? There's no downside. And it's, as I said, not about business rescue. It's about us reaching out to your creditors and getting them to settle. And I just want to conclude by mentioning that a business rescue plan can be very, very simple. And at the moment, there are quite a few insurance claims out there, and insurance companies are repudiating business interruption insurance. So a business rescue plan can in itself only be litigated for the purpose of the insurance policy, because that may be what's required to save the business. I'd like to thank my panelists, and I'd like to thank the audience. Thanks so much for today. We on every single day. In fact, we often on more than once a day with our targeted and specific webinars. Thank you very much. I hope to see you again tomorrow. Bye-bye.